welcome everyone. This is the final workshop of the February 2024 administration for the Florida bar exam. Next week, we will be doing proctored exams on Monday and Wednesday. We asked the class before the recording if they preferred 2 or 3 hours exams. It was a perfectly even split. So I'll have the proctors in here at 7 o'clock. By 7:10, testing will start, and we probably won't let people in after 7:10, let's say. So really try to be here ready to start at 7 o'clock. They'll read the directions, and then I'll instruct them that 7:10 is when the exam precisely begins. On test day, when you take the bar, it's going to be a mental process where you get to the exam, you wait in a security line, you get to your seat, and then you sit there for like an hour. And it's exhausting. So we're going to replicate that with maybe 5 or 6 minutes, right? But don't be upset that that's what happens. Have a plan in mind, and I'm going to teach you a plan, right? The plan is the memorized introduction for ethics. We're going to memorize code, and we're going to recite it in our minds. And then when we get to the exam, when the exam starts, we're going to write it down first. Cold memory. So the whole time you're sitting there, that's what you should be thinking. That's what someone like me, someone who's a trained champion would say, right? That you have to have a plan in place for success. And you never want to go into battle cold. You want your mind to be running. You don't want to be, you want to be stretched. You want to be warm, and you want to have a plan to hit the ground running. So the way that we're going to hit the ground running is with our ethics introduction. We're going to have it memorized cold and be able to quickly write it down, and then we'll figure out which essay it's going to go on and where, but at least we will be focused on something. I don't like, well, maybe I do like it because I'm competitive and I kind of am competing against other people when I'm taking the test, but I see other people who their minds are spinning before the test. Well, you're going to spin right out of control when the test begins. You want to have a calm, cool, collected, and focused mind. Channel the energy. So you want to channel that energy, in my opinion, in the morning when you're doing essays on memorizing some poem, To Be or Not to Be, Two Roads Diverge in the Yellow Wood, Life for Me Ain't Been No Crystal Stair, right? Poetry. We want to turn this into poetry and have it precisely memorized so that we can write it. That's going to be one of the main goals of today, is for everyone to have memorized ethics so that they can feel confident when they're going into the test. They can have some voice playing in their mind of what they should be thinking about. You think about it, you recite it, and you get a lot of points. And then off the bat, while other people are struggling to catch their breath and reel it in, you're already getting like 10 to 12 points just on following the program. So today we have plenty of time to talk about ethics and family law essays. So I do want to start just by sharing some procedural announcements, let's say. Doesn't need to be announced that Biscuit and Rosie are not behaving. That's a given. So we have the blank Florida essay questionnaires. That's the #1 resource for essays. You should be able to go through these questionnaires cold and answer every single one blank. We're definitely going to do that on Saturday, next Saturday, for the final session of the year. That's without question, because that's the surefire way. I have had a student named Ben. He scored super high on Florida, and he gave all the credit to these questionnaires. He said it was like I was in a school play and I had memorized my lines, and then I just said, for 40 days and 40 nights, it rained and rained and rained. That was actually my line in the first grade play when I was or not even first grade, like preschool. And everyone said that I crushed it because I said it with such confidence, because it was my only line. For 40 days and 40 nights, it rained and rained and rained. It was like the biggest moment of the play. All right, so here we have the boot camp assignments. So first thing is the questionnaires. You want to memorize all them. Boot camps, we have essays assigned, multiple choice questions. That 1 week of my boot camp, I think, has been pretty solid, you know. For everyone who's in my boot camp, that's 366 days a year for me, right? I'm very focused right now. I believe in 20s is for learning, 30s is for earning. I'm in my 30s, so I'm working around the clock. And if you're in my boot camp, you can kind of get a sense of how I operate. So follow along with the boot camp assignments. I've been adding student outlines. So Will's essay cheat sheets, and we'll see something cool from Will. Will was my former student, current tutor. Last administration, he took on 2 students. They both passed. He wrote these cheat sheets up. I'm sure they'll sound familiar because I was his tutor, and that's kind of the flow of water. But pretty awesome, these cheat sheets. So you could kind of check them out and see if some of these could help you in your studies, and I'm sure they will. So I've had some students, Hannah and Danny, send me some outlines. I don't know if you guys are all just being selfish or what, but I'd love some more outlines. I think it can only help. This is a, closed universe class where only the students in the class have access to the outlines. So, if you're friendly, like Joel, these outlines are fantastic. I would highly recommend going through Joel's outlines. For instance, I really like the way he did this album cover, Risk of Loss. No, I really like the way he did crim law, because at the way bottom of his crim law, actually not crim law. I mean, I do really like the way he did crim law, but I'm actually looking for, I don't know if I could find it. Oh yeah, here it's Florida criminal procedure. I'm like, how could I have lost it? Things like that just don't go missing. Or do they? So anyway, at the bottom of his crim pro outline, look how beautiful this is. Green and red, Christmas in February. He has a cram guide. You know me. I'm the king of cram guides, right? I love cram guides. He made cram guides for Florida multiple choice crim pro. Cram guides, cram points. He did it for you. You just have to read them over and over again, right? I really, no one is going to be able to tell me Ibis Prep didn't give students resources, right? That's kind of what the only feedback I've had in the past was, oh, some of the other companies might have had more resources than me. Not anymore, right? We have the most resources in Florida by far. I have Amy's materials. Amy was former student, current tutor, all of her crim pro time to do shit. Yeah, see, Ibis Prep, we're allowed to curse, right? We can do whatever we want here. I heard the boss is pretty cool, right? This is a great sheet that you guys can use, right? It was made by her for you, and she'd be so happy to know that you used it. And if you do use it and it helps you, you can mention it in a Google review or something, right? A lot of things. And look, she got a video. She's cool. Like there's so much stuff here. Danny's outline and Professor Tamayo, who is my professor in law school. Everyone loves her. This is her ethics outline. Like, and Professor Tamayo, please, I'm using this with your permission and love. We were students in her class, and I know you would want to help students. She's a really, really good person. Anywho, this is pretty awesome, right? If you really care about ethics, holy banana peels, read this from top to bottom. I'm going to try and make it a little more simplified today, but the more you know, right? The more you know, the better it will be. So that's just kind of an introduction to the resources, study goals. This week, the assignment is, this weekend to write the 2 family law and ethics essays. That would be like the first thing that I would recommend.
Class.
Sorry. That would be like the first thing that I would recommend is doing this assignment, the family law and ethics essays. And after that, jumping into these multiple choice assignments. The more practice you do, the better. And then you can always go back to any of the subjects that we've done throughout the administration. I'm proud of my team. This is the first time we use a Google Classroom, and I think you should all find it pretty valuable. These are questionnaires, memorize these cold. These are essay cheat sheets. There is no cheating on the exam. Like James and I are going to come to Tampa, and we might pass out some, cup things, right? Cup holders, not cup holders, but things that go under cups. I don't know where we're going to get. We have to talk to my guy, Alexis, but not Alexis that works with us, another Alexis, a guy. But anyway, we're going to come up with some materials in Tampa to give you that'll have some pointers, but certainly they're not used for cheating. They're used for reviewing, on your own in the hotel. Like there's no cheating, but this is shortcutting, right? Learning the material beforehand in the most effective manner. Then we have Joel's outlines, super duper triple fire. I mean, this kid got a 156 out of thin air. You know, he went to St. Thomas Law. He is a smart kid, and he wasn't, you know, top of his class, or he wasn't the he's just a normal kid. He's like, you know, he's like one of the guys. He's my man, Joel, and he got a 156, and it's proof that you can put your mind to something. And look how hard he put his mind to. Makes me laugh. All right, and then this is more of his. This book is coming out on Monday. I know you guys can't wait, but I've been writing a book, and look, I have all the torts done. I have all of I've gotten down to work with con law, right? I was working just before on this little discussion, traditional public forums, designated public forums, limited public forums. You know, I have room to go, and it'll be finished by Monday. It's going to be available for purchase for $69. That's the number we mathematically decided was most reasonable. And it'll be free for everyone who's an Ibis Prep student already. So my book is coming out on Monday. That's a promise. No one's going to work harder than me this weekend on the Tim Tebow vibe. And then I just want to show everyone what I call the pudding, right? I've found out through the grapevine that people kind of doubt me. It's crazy, right? How could you doubt me? I've been doing this for 7 years, 94 5-star reviews, nothing, not a peep anti. And you see, like, we don't just do the bar, you know, this lady, you know, works with Ronald. Yeah, Ronald's the man for AP Geography. I mean, we do everything. I'm the founder and owner of the company, and I teach a lot, but, you know, Lauren, you know, great tutor, whatever it may be. But this is what I really want to focus on. Look at EJ. He's it's perfect timing, you know, serendipity. Who just, I'm gonna wait 1 second. Hey, Taylor, what's up? You're with us?
Yes, I'm here. Hello.
I was just showing off EJ's 5-star review. I was like, how serendipitous. I'm just trying to show people that if you're worried and you don't think that this works, I'm showing you pudding right now. EJ struggled to pass multiple times. He's a full-blown NFL agent making big deals right now. Gabrielle has not only passed Florida with us, she's passed the UBE. Sade, she came to us, reached out. Andrew Salmon, she worked with Will. One time and done with us. I don't know how many times she took it before us, but one time and done with us. Grace, who's here, amazing. We told her to split up the test, so she did. She sat for the MBE and got a 141, and English is her second language. You know, this isn't not our first time. Amy Trentalage, here you go, the tutor who I've added all of her materials. She's absolutely the way to go. She passed on her 5th attempt. My methods were fire. Matt Beckerman is awesome, right? This is proof. Natalie Landman, she came to us, you know, no words to describe what we did. She failed on her first time. She was super nervous. She went up 20 points. She came to my boot camp. I signed her off, and she passed. Working with me and Matt Beckerman was awesome. And she worked with Amy, our former tutor. Lexi Johnson, who was a Dean's Fellow for Maria, who's now in my boot camp. You know, she failed the bar twice, came to me once. Her score went from 121 to 141. We really helped her out. Ariane, I tutored Ariane. She last administration. She failed on her first attempt, came to me, knocked it out of the park easily. This person, it's not her real, I don't think that's her name actually, but maybe she's being secretive. But she wrote the model answer. She's my student who wrote the model answer. I told you one of my students wrote an answer that they published as a model answer. That was her, right? Treasure chest. Me and her worked together. She was a full-time working attorney with the family, and we put in that work. Paolo worked with Amy, who is no longer with us, but amazing instructor. Tariq, he's a good personal trainer. Mark worked with me, passed. I mean, Sam Fallick worked with me after failing, and then he had passed. Carla, she said just turn on our videos, and she passed. Sam Collier, who's probably one of your instructors, 17-point increase. Joel Brodsky failed the test, came back 156. We gave you his outlines. I mean, May, who worked with Robert, she passed. I could go on for years. Ben, who I told you was the one who said our questionnaires were the difference maker. This kid Salo, he came to me, he said, only doing 2 to 3 2-hour sessions. I think we did more than that, if I recall, but we did some sessions down the stretch. and I told him how to do Florida multiple choice. He was a guy who he wasn't committed to the hardest study. He said, "What can you tell me that'll work? The shortcut to passing this test?" And I got limited hours to study, and I said, "Do this and do exactly this." And he said, "If I do that, you promise me I'll pass?" I said, "My word is my bond." And boom, he's up here. This person, this is also a code name, right? We're the best supplement on the planet. These are real people, right? This is Roberto from St. Thomas, worked with me and we passed. This is the one that I wanted to show everyone. Will Watson would die for Ibis prep. He came after demoralizing failure, and now you have his cheat sheets. Like, I don't think, and then I said nice video, by the way, because he's the one who gave us the Tristy Dunks mnemonic, right? Testamentary, resulting, spendthrift, inter vivos, discretionary, oral, no contest, charitable, semi-secret, secret, support, spendthrift. I don't know what that stands for, but I got that from Will. I learned from my students, just like my students learn from me. Carter, you know, I'm not gonna, I mean, I really could. I could go all the way down in world history, but this is something that we really do here, and we've been doing for a very long time, you know. Edwina, I tutored her for the LSAT. Hey, she should be in my bar prep course by now. I wonder where she's at. All right, anyway, just enough. I wanted to take the time to do that. And if you thought that I was just boasting about my company, I'm not. I'm trying to instill confidence, you know. Don't listen to the defamations that said about us. We have real students who have passed this test, and I pour my heart into it. And this administration, no one can tell me I haven't gone harder than ever before. Unfortunately for y'all, I'm probably gonna go even harder in July. Like I happen to get better with time, like fine wine. Speaking of that, one thing I did want to add is we've signed up a team for the corporate run. So I'm going to give everyone the challenge of the lifetime, because I know everyone complains, you know, they waste all this money in bar prep. I'm going to give you a chance to make some of it back, right? So this right here, this link, I'm going to put in the group chat. I'm just going to stop the share real quick, but everyone can get this link. In April, this is the Miami corporate run. The Lexus Miami corporate run is a 5K event. You can sign up for the Ibis prep team for free. I'm paying for all entries. And as a challenge to you or any of your friends who would like to join my team, I'm offering rewards, plural, of $250 for anyone who can get a faster time than me on the 5K. So if you sign up for free, join my team, all you gotta do is beat my slow, dusty ass in the 5K and you'll win $250. That's a fact. I will just show you. I do have some gold medals to my name. I'm not someone to play around. Just as I'm good at teaching the bar, I'm also pretty good at a lot of things. And the 5K is something that I don't see paying out the $250 to anyone, but I would be very happy. And no matter what, I'll be donating to charity anyway. So that's that. You can definitely join my team. I'm excited to hopefully see some of you out there. I don't know if I'll see you because you'll all be behind me, but you know. All right. And then anywho, let's get down to business, right? That's the most important thing. So we talked about what the work is. We have proctored exams on Monday and Wednesday. They'll be from 7 to 9 if you're doing a 2-hour exam, from 7 to 10 if you're doing a 3-hour exam. It'll be Rachel or Inez or Lauren, someone younger and cooler than me, you know, even though the proctors at the actual exam are not that cool in my experience. That's not defamation, that's just my opinion, testimony. But I'll have one of my instructors or admin people come in here and proctor the exam so it feels like a real exam. The Zoom room will open, you know, at the latest 7 o'clock. They'll read instructions and the test will begin promptly at 7:10. If you come in after 7:10, they have discretion not to let you in. Okay, so without further ado, let's talk about ethics and family law today. And we're going to realize that these are subjects we are praying for. Family law is probably the least likely subject to be tested on essays this year, but by no means should you disregard it. They've kept narrowing down what subjects they're testing in Florida for essays to the point where they could test all of them on a singular exam. pretty easily, if you ask me. All right, so I think I want to start, I think it was 2014 with this torch contracts ethics piece, right? We did this in my boot camp. Does anyone know why I chose to start with this essay? Anyone take a guess? It has nothing to do with how fast I am. Or the Dan Marino jersey I'm gonna wear at Tampa in next week. What it really has to do with is this. This is where we got this introduction. We are all gonna memorize this cold. We are going to have it in our mind, replaying like, you know, the Philly special in 2018 when the Eagles won the Super Bowl, right? We're gonna just play that moment over and over in our mind as the test is coming up, right? We're standing in the security line, and then we're getting in, and then we go there and we sit down, and then we realize we're sitting down with someone who kind of has an odor, and then we realize that the bathroom is kind of a hike, so maybe I should go to the bath. Like, there's a lot of thoughts that are going to go in your head. Trust me, it won't be silent in that room. There will be noises, right? Human beings sitting in a chair make noises. And these are things that you're gonna have to be prepared for. So what should you do? Block out all the noises and just say this to yourself over and over and over and over again. I would recommend everyone who's watching this video to write this down as I repeat it. And then just give me 1 second to clear my throat. Sorry. So I would just recommend that everyone out there write this down and repeat it. For me, writing down is always the way to memorize. One of my superpowers, let's say, is being able to memorize poems. And I'm in a business networking group, and I honestly could win commercial of the week pretty much every week if I wanted to, just because I think everyone else's commercials are lackluster and like I have a little pizzazz, right? But I don't. I usually keep it chill. I'm like, hey, I'm Andrew. We do tutoring. If your kids need help in math, call me, right? Like, I'm pretty low key, but when I want to win it, I know exactly how to win it. And I don't even have to prepare for it. I just go up there and recite a poem that I know from memory. And then people are like, wow, you're like Doogie Howser or something. It's like, nah, I just memorized this poem when I was in 10th grade and I never forgot it, right? So how do I memorize things? At some point, it's always the same way. You take the poem, right? And then you take like the stanza and you write it down using a pencil, and then you write it down, and then you remember, and you turn it over, you write it down. And at some point, you've done it enough where you've memorized the first stanza. Then you go down to the second stanza, and now you memorize the second one in conjunction with the first, turn it over. And once you memorize the second stanza, you go to the third. That is how the process of memorization works. There is no superpower. So when people think I have a super memory, I don't. I actually just have a super work ethic, but not even really. I'm pretty normal. Like, if you know me, I probably do more fun things than most people because I compartmentalize. When I'm working, and when I'm playing, right? So when I'm working and trying to memorize, I'm one stanza at a time. Get it, got it, good. To be or not to be, that is the question, whether it is nobler in the mind and suffer the slings and arrows of outrageous fortune, right? Same thing here. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. That's the big piece. You could potentially get 5 points for mastering 5 pieces, right? Where do the ethical duties come from? Number 1, the Florida Supreme Court. Number 2, the Florida Rules of Professional Responsibility. Number 3, the ideals and goals of professionalism. Number 4, the oath of admission to the Florida Bar. And number 5, the creed of the Florida Bar. And the final catch-all, other documents. They could potentially give you 6 points for that sentence right there. I'm not saying they will or they won't. You know, I'm not the grader, but they're not going to give you 0. And they could potentially give you 6. So if that were the option, would you rather take 0 or potentially 6? It's not a question. Would you rather take a guaranteed 3 or a guaranteed 3, potentially 6? Like, not even an option. So always try to stretch your language to get more points. Try to make it impossible for the reader to fail you. That's how I'm teaching how to write essays. That's how my student wrote the model answer. Write the essay so that the reader, how dare they even think about failing you? Because if you're going to pass Tommy or Johnny, well, you got to pass me because I wrote everything that Tommy and Johnny wrote together plus more, right? Like, that's how I want you to write these essays. Don't just be like, I answered the question concisely. Please, sir, may I have your request of a passing score? Like, no, like, bro, I wrote everything, man. Like, if you don't pass me on this, there's gonna be problems between us because, like, how could you dare? I wrote everything possible, right? That's how we want to write these essays. So I started with this for a reason. I really want everyone to memorize those 6 things. The Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. Here, the ethical duty at issue concerns attorney's prospective representation of seller. The facts state that the attorney is set, whatever. It's right here. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. We're going to learn a lot of little pieces we can add to this. Like, what are different ways that they can be sanctioned? Admonishment,
Expulsion.
expulsion, or
I think suspension.
suspension. Someone's been studying with the king himself, right? I'm so happy that you stepped in, Gabby, because I was about to have to think about it. I don't like thinking, right? Expulsion, suspension, admonishment. We can add that. So you can see, Gabby, we've been working hard. I'm proud of both of us for how hard we've worked together. And I think the results will show she's memorized this. How? Because the same way anyone could memorize it. Same way Joel memorized things. Same way Tommy and Johnny do. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. Types of discipline include admonishment, suspension, or banishment. What do we call it? Term expulsion, right? Admonishment, suspension, or expulsion. 3 more words, right? 3 more words. The more words, the merrier. And that's amazing. So
I'm sorry.
go ahead.
What does admonishment mean?
Admonishment means like you're publicly chided, or someone give me
Oh,
a
they
better.
call you out in public?
Yeah, I was looking for a higher legal word than call you out.
Okay.
Chastised. Go ahead. Reprimanded. Yeah, there we go. There we go. You're publicly chastised, reprimanded, chided, called out in public, right? Like made to look like a fool, right? That's admonished. Good question. Okay, cool. So what else happened here? There's no ethical rule against representing one's personal friend, although an attorney should be cautious to separate the attorney role from the friend, especially in matters relating to the duty, undivided loyalty, and duty of confidentiality. So cool stuff. I wanted to start there for a reason, because that right there is like, you're killing it. I'm writing that right off the bat. Is everyone cool with this? I'll read it one more time just because it's just like Marvin Gaye on a Saturday morning. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. Here, the ethical duty at issue concerns attorneys. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. Types of discipline include admonishment, suspension, or expulsion. Beautiful. All right, cool. Before we go on to another essay, I just had an idea that came to me. Why don't we look at Will's cheat sheet for ethics? See what he's got going on. So, what do you know? What do you know? It seems like the formula has not changed for many years. Man, this is getting easy. All right, law practice. You have to be barred in Florida except association with an active local lawyer, like a temp, pro hac vice admission. It's not spell that right yet. Admission, practice arising out of the home state. So like, you're getting temporary exemption to practice. Lawyer employed by only one client, like in-house counsel permanently, or practice in restricted branches of law, like federal agencies, could be permanent. Like I have a friend who took the Florida bar. It's actually like my best friend in law school, JP. He's the man. That's my quarterback because we played flag football in law school together. He's good at football. And he went to pass the Florida bar and then became a JAG officer in the Marines. And yeah, he only had to pass the Florida bar. You just have to pass any bar exam, and then you could, he did some cool stuff. He's a cool guy. JP. I just had a kid too. All right, so law practice, you got to be barred in Florida except for these situations, which would allow you to either temporarily have permission to practice or permanent permission to practice based on an in-house counsel position or a federal agency position. You can't assist people to the unlicensed practice of law except can give some advice to pro se people, right? So look out for that, the unauthorized practice of law. Supervisory attorneys must make reasonable efforts to ensure that actions by subordinates conform to the rules of professional conduct. Supervisory attorneys are responsible for subordinates' acts if he or she orders or ratifies act and knowingly fails to take remedial action. So subordinate attorney can safely follow supervisor's directions regarding reasonable resolution of an arguable question of professional duty. So usually if there's a senior and a junior partner, and the senior partner is directing the junior partner, they could potentially both be subject to discipline depending on the occurrence. If the subordinate attorney did something knowingly unethical, he should be admonished and or suspended, terminated. And the supervising attorney also has to make reasonable efforts. So they could potentially almost like a, supervision theory. So you definitely want to talk about that. On the bar exam, put yourself in the shoes of your most trusted moral figure, do the right thing, like in the most sanctity. I would recommend that Tommy does not take the litigation, or at least receives confirmation consent from the client in writing and advises the client of the desirability for seeking independent counsel, right? That's a nice kind of way of being like, even though this is probably cool and I could do it, I would still advise him of these things just out of an abundance of caution. So that's not you remember that, abundance of caution? Okay, sale of a law practice. Someone made in the chat, someone remembered it. Oh, so someone made a point. Let's see what it is. It's like the show Suits, how the supervisors, Harvey and Jessica, faced ethical violations for Mike, employee, practicing law without a license. I've never seen that show Suits, but I get people tell me about it all the time. But I get it. So Mike is practicing law without a license. That would be called the unauthorized practice of law. Harvey and Jessica could be responsible and be admonished or suspended or expelled for allowing such unethical behavior. Certainly. It's always good to watch TV, except not really. I don't actually believe that. Less TV, more reading. Okay, sale of a law practice. The entire practice or practice area must be sold. Fees to clients must not increase as a result of the sale, and they must give written notice to clients about sale and provide opportunity to retain other counsel or collect their file. So you can't just sell a little, a book of like a piece of business. Like I'll sell off these 3 clients, right? You have to sell the entire practice or practice area. Your fees to clients must not increase as a result of the sale. And you must give written notice to clients about the sale and provide opportunity to retain other counsel or collect their file. So this is for, people who have retainers. It's like, hey, I'm selling my practice. I gotta give you notice and the opportunity to retain other counsel or collect file, right? Pretty reasonable. A lawyer cannot engage in a business transaction with a client unless the lawyer makes full and fair disclosure of the terms of the deal, confirmed in writing. The deal is fair and reasonable to the client, and the client is informed of the desirability of seeking independent counsel with respect to the transaction. The way that these essays are properly written is like a lawyer cannot do this unless. A lawyer cannot collect referral fees unless. It's unethical to do this unless, right? You really want to come from that school of thought that the lawyer on the essay question is under a watchful eye. Think about it like that. The lawyer is under a very watchful eye and doesn't want to do anything that would give rise to an air of impropriety. All right, let's talk about duties. So, CDC. CDC. Isn't that something, the CDC? Weren't they involved in COVID somehow, the pandemic? I'm gotta get off of that. I'm over the pandemic. It was probably real. All right, confidentiality. Is the CDC then? The CDC. But I will say this, to be fair, I'm gonna mention this. Multiple people are getting sick right now. Like I'm not a maximalist. I think maximalism is the downfall of society. I think that maybe we went overboard with the pandemic thing, but I don't disagree with masks. I think masks are actually a way to protect people from sickness. I have noticed some sickness in amongst my students, and it's very normal. I said it in November. I said it in December. People always get sick right before the bar. Why? Because you're exhausted, you're overworked, and these are contributing factors to sickness. I mean, hello. So we have to combat that. Drink tons of water. I mean, I drink my apple juice, but you got water on deck, right? Need more in there. But stay hydrated, eat healthy. I just went to this place, Buzzies in the Grove. It's like my new favorite spot. Super healthy, good food. Get as much sleep as you can. If you study or sleep, nothing else except eat well and exercise. Like you really do want to be in a good mental and physical place on test day. It would be an absolute shame if you're very, very sick on test day because you overworked or overstudied. The other thing is, if you are feeling a little bit ill or whatever, mask up, especially if you're in my boot camp. I don't want people coming there that could potentially be sick. Let's be respectful of everyone. So if you're feeling a little bit ill, mask up for sure. All right. So let's talk about duties, right? That would be the ethically correct thing to do. I believe in that. All right. So anywho, sidetracked. Confidentiality is absolute unless the client consents, implied authority was previously given, preventing future crime or harm to another person, detect, resolve conflict of interest. Different than attorney-client privilege, which covers all information and representation, however, whenever it was obtained. We talked about that on my lecture, how confidentiality is similar to attorney-client privilege, but the duty of confidentiality is even greater as it survives longer and it is more broad.
It survives death, right?
Survives in death, yeah. So decorum, duty of decorum, honor, integrity, and fair play, commitment to equal justice under law and to the public good. This also reminds me of something. Jesse has fixed our Florida evidence multiple choice questions, so they're no longer written like this because Lord knows nobody likes things written like this. Honor, integrity, and fair play, commitment to equal justice under law and to the public good. So decorum, I think of decorum as acting appropriately inside of the court, and candor as acting appropriately outside of the court. But that's kind of lazy definition, right? This is more appropriate. Honor, integrity, and fair play, commitment to equal justice under the law and to the public good. And then candor. A lawyer must not knowingly make a false statement of material fact or law to a tribunal, fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, or knowingly offer false evidence. So decorum, candor, confidentiality, I mean, you can kind of drop all three of them on your ethics without risking much. Remember how this test is. You get points. You don't get points for going, outside the scope. You don't get points off for going outside the scope. You just waste time. But if you have the time, you could say, here, if Tommy acted a fool inside the courtroom, right? You're allowed to give mini hypotheticals and move forward. I think everyone can kind of see I'm naturally like that. I was just talking about like wearing masks because of the CDC, and then boom, came right back into this. Is the CDC even related to masks, or am I getting that mnemonic acronym wrong? No one's messaged me. The CDC, they are the people, right? Who said, okay. All right, nobody's saying anything. I just assume that I'm talking to myself. All right, so candor, decorum, and confidentiality. These are key pieces. Confidentiality is even greater than the attorney-client privilege. Decorum is honor, integrity, and fair play. Candor is not knowingly misrepresenting anything to the court. Also look out for filing frivolous complaints to the court. That would be a violation of duty as well. Yeah, okay, CDC, Center for Disease Control. Okay, good. That's what I thought. I was like, I'm not crazy. I'm just a little unwell. Okay, conflicts of interest tested all the time. Lawyers cannot represent a client if a lawyer's judgment will be impacted by the lawyer's responsibility outside the representation, except the lawyer reasonably believes representation won't adversely affect and the client gives informed consent. Former clients can't represent new client in case in which old client will be adverse unless you have old client consent. You can't disclose confidential information and material in order to disadvantage the old client. Prospective clients must be an authentic seeking of representation services. It can't represent new client who is materially adverse to a prospective client, divulge information learned during the consultation, and it will be imputed to the rest of the law firm unless informed consent in writing. The lawyer took steps to avoid disclosure, is timely screened, and the prospective client gets notice. So boil this all down. Conflicts of interest, former clients, prospective clients, imputing, screening, right? Just kind of ding, 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 use those big words. Imputations. Conflicts are imputed unless personal to lawyer or the conflict doesn't risk materially limiting representation by rest of firm. When a lawyer leaves a firm, imputation leaves them unless same issue and any lawyer in firm still has detrimental knowledge. Cool. So Will, I like what Will did here. He made CDC a thing. Instead of Center of Disease Control, we're going to think of CDC as confidentiality, decorum and candor. Confidentiality, decorum, and candor. One thing you'll notice about Will, my former student, current tutor, he's huge on mnemonics. He's still available for tutoring. He was supposed to take the UBE and then he postponed, I think. So he said he could take on students. I don't know if he's actually gotten any. So if anyone wants to work with Will, Will's the man and he's available. All right. Finally, Karen. This is like the word of the last few years. I have a cousin named Karen. No comments. Contingency fee. No domestic relations or criminal cases. Must be in writing and include signature, percentage attorney will receive, whether other expenses are included and when they'll come out. Attorney's fees are permitted by statute, rule, or sanction, right? Must be reasonable, clearly excessive when overreaching or unconscionable. Could be by contract too, I guess. Presumed reasonable if agreed in contract and writing, right? In contract too. So attorney's fees are permittable, but they have to be reasonable and can't be overreaching or unconscionable. Referral fees, and this is what I said, referral fees are unethical. They're not allowed unless the lawyers work, cohesively on the issue and accept liability, and they disclose to the client how the fee will be split. The interest in client property must be fair and reasonable, disclose in writing, advise client to seek outside counsel, and get clients informed consent. And then no commingling. Advanced payment of costs and expense can be kept immediately. So no commingling. We use that word commingling a lot. So Karen, what does it stand for? Contingency fees, attorney's fees, referral fees, interest in property, and no commingling. Contingency fees, attorney fees, referral fees, interest in property, and no commingling. Karen, right? Karen would definitely be the person you should think of. Like, you violated rule 8.7, be like Karen. And the Center of Disease Control. You have to wear a mask when you drive your car. And I don't know why I'm talking like that. I just need some humor in my life. All right. Communications, ads. Must contain attorney's name and field. Must be registered with the Florida Bar. Must not be misleading. And what is misleading? It contains a material statement that's misleading or false. Like, see, when I showed y'all our reviews, that's 94. I think 2 of them got, I'm not going to speculate. 94 5-star reviews. That's proof. That's pudding. 100, one win, and then you go out and advertise that you have 100% win rate is certainly misleading, right? Because it's omitting vital information. Implies the existence of a non-existent fact. Like, I'm the greatest family law attorney, and you've never even had a divorce case. Like, that would be pretty messed up. So communications, you may not solicit, but you can send a letter to a prospective client 30 days after the incident. Must tell them how you found them. I mean, you just chased them. You filed the ambulance. Speaking to represented people, you can't talk about the matter for which they're being represented. And speaking to unrepresented people, you can't appear disinterested when not disinterested. You mostly should tell them to get an attorney. Let's see. Hector says we also got who? The World Health Organization. What does that mean?
It's like the CDC, but for the whole entire world. So CDC is based for the United States, and the WHO is, it's like kind of like UN, or what is that called?
I know, but I thought you
Uh,
said it was an acronym for the bar, but
oh,
it has nothing to do
no,
with the bar exam.
no, it does not.
Okay, no. Yeah, no, that's, trust me, I love side tangents, but I thought it was like, don't forget about who, which is like, I don't know, I'm not gonna create something that doesn't exist. But anywho, this is a great outline. Way to go, Will. You get 5-star review. You had this paragraph we're all gonna memorize, talked about some important things like, you know, the sale of law practice, CDC, confidentiality, decorum, and candor. Conflicts of interest is just a major thing that's often tested. And then Karen, contingency fees, attorney's fees, referrals fees, interest of client property, no commingling. And then he hit us with the communications piece, super duper triple solid. What I'm gonna do for a little bit, I'd say like 15 minutes, is just show you ethics in real speed and just show you how ethics is done and how we're gonna do it. Our ethics parts are gonna be better than all these model answers. That's like, when I coached basketball, my team won the championship and they were 12-year-olds and I taught them how to shoot free throws. And I was like, look, just get to the free throw line and make free throws and we'll win all the games. And I was right, because these kids can't help themselves from fouling. Every time the ball, like, it's up in the air, every time the rebound, it's just. All right, let's see what's going on with this ethics piece. So we have a thing right here. They saw an attorney to advise them about the rights. Oh, by the way, if you want to know, this is question 3, July 22. They saw an attorney to advise them about the rights with respect to sellers in the alarm contract. They consulted with Smith, the sole lawyer in the firm. Natalia and Mitchell saw an advertisement online for the Smith law firm, which Smith was identified as the founding member of the firm. The advertisement also stated, cheated, I'll get your money back. During the consultation, he explained that he handled similar matters since he began practicing 2 years ago. He also told N&M that in order for him to accept the representation, they would have to agree to submit any disputes regarding legal fees to mandatory arbitration. So again, if you see something you don't even never heard about, kind of just assume it's unethical. You know what I mean? Like, look at it, be like, that seems kind of shady, right? So here they're saying any ethical considerations raised by Smith's conduct. I'm gonna tell you what I would do. You don't have to do what I do, right? Like some people, everyone does things differently, but this is what I would do. I would write ethical considerations first, because I like to start things off with confidence. It's like when I run these races that the challenge is out there. And by the way, it would be super unethical for you to go tell your freaking friend who's like a world track star to go win you the money. Like, come on now. It could be a friend, but like a real friend. Can't be like, you know, you went to Kenya and hired a track team. But I mean, I'll try my best. Anywho, you know, when I run a race, 2 things about me why I usually win 5Ks. One, I always start sprinting out the gate because I just tell myself it's not that far. I can sprint pretty fast. Let's just see how far I can go until it kind of catches up to me that I'm tired. So by then, I'm way ahead of everyone. That's always been my strategy. The best races I've ever run, I've full out sprinted to started, and then like eventually I'm like, all right, gotta catch your breath a little bit. But by then you're so far out of the gate, you know, like a horse. That's how I would do it. I would just bust out of the gate writing about ethics, and I'd write the world's greatest ethics piece. So by the time I kind of went back, not by the time, like it's gonna be quick. I'm gonna take like 8 to 10 minutes maximum. But after that 8 to 10 minutes, while the other people are having their stomachs are twirling and they're freaking out, like, oh my God, I'm gonna be back here in July, or like, do I even want to practice law? Or like, should I even be in this room? Or like, that girl's kind of cute over there. You know, they're all in the wrong place. I'm going to be so far out of the gate. That's the one way I run races. The other way I run, and why I usually do pretty well, is once I see the finish line, or I feel like the finish line is in sight, I start sprinting again. Because I'm like, all right, well now, yeah, you know, whatever I got in me, I got to get it out of me. Because once I pass the finish line, I'm going to be like, well, shit, I could have ran a little bit more, you know? So those 2 things, I always finish strong when it's kind of dawns on me that's like, oh, the end is, you know, my wrestling coach, that was actually my top sport growing up. My wrestling coach used to say, he's a weird guy. No, I love him. He's not a weird guy. He used to say this. Most people die within a mile of being saved. He used to say all these quotes that kind of made sense and kind of didn't. Like if you thought about it too much, it either made more sense or less sense. But that was one of them. Most people die within a mile of being saved. And he used to say that all the time. And it just meant like, yeah, bro, it's 3rd period, a minute left. That's when most people give up, not us, you know? So we're going to finish strong. So I can boil that down into bust out the gate and finish strong. And that's pretty much that. So let's bust out the gate and see what's going on with this ethics piece. Man, look at all he did. That's it. Look at his ethics piece. That's it. If that's what he did, I mean, that's the model answer. That breaks my heart almost. The Florida rules of professional responsibility state that advertisements must contain a disclosure in red that is an advertisement on the envelope in the first page. The ad cannot, you didn't even spell this word right, man. Like, come on, man. Come on, buddy. This is like painful. The ad cannot guarantee results or make misrepresentations. Here, the lawyer guaranteed money back and represents himself as a founding member when he's only practiced for 2 years. Like, that was the big thing to me. Founding member, he only practiced for 2 years. Like, I'm a founding member of Ibis Prep, but like, I still think of us as like a young company, and we're 13 years in, 5 years in LLC. Founding members, come on, bro, you didn't really do much. Therefore, they're a violation of the rules. Here we go. The mandatory arbitration is permissible as long as the client is provide a copy of the client's rights and give an opportunity to review. The client must be informed and she can retract in 3 days. I don't even know truth to this or not. I just know that my ethics discussion would have been so much better than this. I would have just talked about more and just gave the reader more. I would have started off with my, entire statement about where the rules of ethics come from. And then I would have talked about the 2 pieces as IRACs, issue, rule analysis, conclusion. What did they do? They ran out of time and just threw something out there. Hey, that's the model answer. I wouldn't say to do that, but it just goes to show you that, like, all right, this one we know very well. I signed this. I think I've signed this. The cutie catering thing, it was intervening, superseding, negligence, can't be putting peanut butter in cookies because then the kid's going to eat it and then fall over. That could be battery because they hit him. Like, we remember this essay. But what about the ethical issue? Cutie Catering seeks advice from your law firm. Cutie Catering received a letter from Betty's lawyer threatening a lawsuit for damages. The letter argues that Betty has incurred medical expenses and lost wages as a dance instructor because of her sprained ankle. It also contends some more things. She was referred to your firm by a lawyer who works for another firm. Lawyer has proposed that your firm pay her 10% of any fees as a referral fee, but she would otherwise not be involved in the matter. That's totally unethical, right? You can't get a referral fee unless you're going to be involved and, they have consent and all these different things. Let's see if this person can make me proud. The lack of ethics. This is sad. Oh my God. Horrible. Trash. Well, we'll just learn. The RPC forbids mere referral fees. Fee sharing is okay as long as there's proper division of fees with the other lawyer. There's an agreement with the client setting out the joint representation, and the agreement sets out the proportionate share and division of the work. So, right, you can't have referral fees. You have to have a division of the fees. You have to have an agreement. And you have to share the work. Here, they're merely seeking 10%. She would not otherwise be involved. It violates the RPC, and therefore, the proposal must be turned down. This because no actual division of the work would not be a joint representation. I mean, that's right. Like, they gave you the simple. So, like, I'm just saying, everyone has a different stroke for different folks. These are the model answers, but I confidently believe that we can outdo these model answers. These model answers are solid. Like, I'm not hating on them. Some of them are really good, but some of them leave a little bit on the table. They leave some scraps for the dogs to eat, right? All right, let's see what's going on in this one. Let's see. All right. Cal's contract with Addie said that payment was contingent on Addie's recovery of the lottery prize money, but Cal did not read the contract. He demanded that Addie and Lori pay him, and Cal's demand, Lori sent an email that said, if you think you can sue me, think again. I know how to drag out a lawsuit for years and make you miserable. Does that sound like an ethical thing for a lawyer to say? Absolutely not, right? So any professionalisms that are going to arise? Let's see if this person can take a swing at it. These are like bunt singles, if these are even getting on base. All right, here we go. There we go. This person hit it like a double, at least, maybe even a triple. See how much they wrote? I just like that. The more you write, the more possible points you can get. It's kind of science or math. So Addie likely will not be able to recover attorney's fees from Lori. Under the American rule, each side is responsible for its own attorney's fees in legal action. Thus, by default, the answer seems to be no. Florida does have a statute permitting recover fees and expenses to the repelling party. If the losing party acted in bad faith, the result respect to litigation, though it is unclear in the pre-litigation stage where anything like that would be applicable. In short, the starting assumption should be that they cannot recover attorney's fees. C-, right? We could do a lot better. We could talk about how, yeah, maybe the presumption, the American rule is that each side pays for attorney's fees, but there are situations via statute or rule or contractual agreement where you can have attorney's fees, right? So we could say a little bit more. What about ethical issues with respect to the agreement? And you can see I'm a very straight grader. So if you don't think my grades have been fair, that's how I grade everything. I just tell you what it is. C- to start. Here we go. Maybe this one looks like a nice A. Lori violated the Florida rules of professional conduct in several ways with respect to her agreement with Addie. First, Addie was a client of Lori, and this was a business transaction, meaning the conflict of interest rule of 4.1.8 will apply. Under that rule, a lawyer cannot engage in a business transaction with a client unless the lawyer makes full and fair disclosure of the terms of the deal, confirmed in writing, the deal is fair and reasonable to the client, and the client is informed of the desirability of seeking independent counsel with respect to the transaction. In this case, we know from the facts that Lori and Addie were clients, and the deal involved them agreeing to buy lottery tickets together. But here, there's no indication that Lori sent any of the terms of the deal to Addie in writing. Moreover, there's no indication Lori ever informed Addie she should seek independent counsel. Lastly, the facts seem to indicate the deal, if upheld in its intended form, was fair enough to Lori, with each party buying half the tickets, but only 1/3 of the winnings potentially going to Lori and the other 2/3 effectively going to Addie. The 1/3 going to her daughter, whatever. Second, Lori might have engaged in unethical fee arrangement with Addie. Under the RPC, any fee must be reasonable. In this case, the arrangement was that Lori would exchange her legal services relating to the money in exchange for Addie's investment services. Without knowing more about the relative values of these services, we cannot be sure whether the arrangement was unreasonable from a fee point of view, but it still seems like that kind of situation at best should have given her pause, right? I like that. It seems like that kind of situation at best should have given her pause, right? She should operate with an abundance of caution. One ethical rule that I haven't seen come up in Will's outline or any of these things that I just want to mention is a duty of competency. And I'm a huge proponent of people writing things down that they don't know or haven't heard before. So I'd encourage everyone to write that down right now. A duty of competency. That means that you have to be properly educated on the subject matter of the representation. You know, Tommy, who's an immigration attorney, cannot take on a criminal matter unless he associates with someone who does such a practice, or he hires a criminal law tutor. You know what I mean? Like, so he learns on it, but like, you know, you can't just take on representation if you're not competent. I think a lot of people who pass the bar exam, you jump into the practice of law and think, oh yeah, I'm going to be I don't know, name your favorite lawyer from your favorite TV show. Probably not. You're probably going to have to work on the floor and then sweep up some, you know, mop up a little bit for 3 years and then switch firms and then get, you know, gain your 5-star review. You know, it takes time. It really takes time. And you have to be competent. And on the exam, you should argue for that. All right, let's talk about the last thing. Finally, Lori violated the Florida Professional Rules of Conduct 4.814. And if you can drop rules, I mean, that's amazing. When she threatened Cal in the email, you don't have to, obviously. You saw what some of these other ethical pieces looked like, but this person's getting an A+ now. Rule 4.84 prohibits attorneys from engaging in conduct such as intimidation or harassment that reflects poorly on the ability to practice law. In this case, Lori made a threat to Cal that she would abuse the legal process by dragging a lawsuit out for years and making him miserable. In short, she used her position as an attorney and her knowledge of the legal system to threaten someone into not pursuing a potentially valid claim against her. Moreover, if she carried through in her threat, she would violate the Florida rules of professional conduct by not conducting litigation in good faith. So yeah, this is solid. I mean, they wrote 1, 2, 3, 4 paragraphs. You know, 4 paragraphs on ethics is a little bit nicer. I think I actually did that back soon. Let's just look at a few more, maybe 1 or 2 more, and then we'll switch over to family law. Family law, not so hard. We can really just, I think family law is probably the easiest essay subject. We pray for family law. It's the best interest of the child. But ethics is important because it's most guaranteed to be tested of any subject. Like you can see here, ethics, professional rules of conduct tested 3 times out of 9 essays. Whereas, you know, con law is tested a lot, right? Con law. That was also tested 3 times out of 9 essays. right? But this is back in the day when they used to test juvenile delinquency. That subject was hard. And Article 3 and Article 9 as essay subjects. I thought juvenile delinquency was like the hardest subject, and the bar prep program gave us like a 1-page outline on it. And I was like, very hopeful it didn't get tested. Okay, so let's see what they got going on here with ethics. Wow, this is a long essay prompt. All right.
What date is this essay?
July 2015, question number 1. Oh, February 2016, sorry. February 2016, question number 1.
Okay,
So,
thank you.
what ethical issues does Luke face and what should he do? So, Charlie tells Luke the following: Luke, I'm in big trouble. 2 guys I work with steal copper for me to resell. One of the 2 guys has been shot dead while pulling off a job, and police caught the second guy. He ratted me out and told the police everything. Charlie wants Luke's help with his criminal issues. Charlie also reminds Luke that Luke must complete the contract between Charlie's company and a copper recycling company, wherein Charlie's company would agree to supply copper to their company for $3 per pound. So this seems to be like you're trying to wrap Luke up, attorney Luke up with some fraudulent activity. Let's see how fraudulent the activity actually is. You see, I mean, this is about ethics. This is pretty much what ethical argument is. It's like 2 paragraphs. You know, if you could push for 3, bully for you, you know, that's what I would say. But don't, as you can see, spend too much time on ethics at the expense of the essay. Ethics is not the main part of the essay, but if you write it first and do your due diligence on it, you actually could get a lot of points while everyone else is kind of head spinning, you know, smelling the room. So when a lawyer is representing a client and after the lawyer passes the bar and they are presumed to have a certain competency level, However, Luke as a business attorney should be concerned. So, right, look at that foreshadowing, duty of competency. However, Luke as a business attorney should be concerned if he is competent to represent Charlie in a criminal matter, since he does not appear to be in his area of practice. A lawyer can become competent in an area through study or working with another lawyer in the area of law. In regard to the criminal case, the fact that Charlie confessed to Luke is not problematic, as he is still entitled to a defense. The contract that Luke is working on for Charlie with the third party is where the ethical concern lies. Luke is not required and may not disclose privileged information provided by his client. However, there's an ongoing criminal enterprise if Charlie continues to sell the copper. A lawyer may not participate knowingly when the use of his service is in furtherance of an ongoing criminal enterprise here to sell copper. Luke should not represent Charlie, see this seems to be a conclusion, in the copper unless he can verify that copper is not stolen. So there are some times where we'll break the attorney-client privilege. One of them is if the privileged information is in the furtherance of a crime. Another example is if you represent 2 co-defendants who are adversaries in subsequent litigation. Well, the conversations that were made amongst the 2 co-defendants are now not privileged because they were made in the same room as the other witness, right? Like it wasn't privileged from them. Kind of ran out of steam on that one. But anyway, this is ethics, right? Not so bad. They're just saying like, you know, they got to become competent and they can't further a criminal enterprise. And the conclusion is they probably shouldn't take on the litigation. Let's see what else. Y'all are so lucky, right? This is what a commercial paper instrument looks like. See how it used to be written on an essay? I, Sam, promise to pay to the order of broker to the sum of 15,000, whatever. Is it commercial paper? Well, this could easily be a multiple choice question. Is this commercial paper? And you would have to look at it and say, well, let me think. Is it a signed, written, unconditional, promise to pay, a fixed sum of money, with or without interest, on demand or definitive time, to order a bearer with no additional undertakings? Does it have those elements? Is it signed? We put his thumbprint on there, that's cool. Is it written? Assumes to be written. Promise to pay, seems to be that. To order a bearer, seems to be to order. Signed, written, promise to pay, a fixed sum of money, with or without interest, so $15,000. within 3 days of the date of this note, so on demand or definitive time, within 3 months, we're kind of, or provide him title of my keys to 2012 Porsche automobile, so a fixed sum of money. That doesn't seem to be like a fixed sum of money. On demand, definitive time with no additional undertakings, right? It seems like this is not going to be commercial paper, and this will actually be UCC contracts. But whatever, that's not what this is about. We're talking about ethics. But that would kind of be my thought on that. Attorney overheard Sam and Sally discusses Sam's legal and financial problems and offered to help. Attorney revealed that he previously defended broker on a burglary charge 10 years ago. However, he felt comfortable he could help Sam and verbally agreed to represent him for a non-refundable flat fee of $5,000. Let's see. What are any ethical issues that we may encounter? So, just gonna see something. Hold in due course. Yeah, it's not one. Why is it not one? It could be viewed as impermissible, right? It was either it's not a fixed sum of money or it's a condition because it was whatever. Yeah, easy peasy, lemon squeezy. All right, let's talk about this. See, this looks nice. I like how they wrote this one. This I think is a good model ethics answer. Okay, cool. Hey, Zach, can you message that message to the whole group, actually? I really like what you said, and they can learn from that. But otherwise, I'm gonna read this too. Attorney's representation of Sam. Attorney's conduct raises 3 issues: solicitation, conflict with the former client, and fee negotiations. Number 1, an attorney may not solicit a person with whom the attorney does not have a pre-existing relationship for personal financial gain. In tort actions, which may be present here between Sam and broker, an attorney may not solicit an injured party within 30 days of the injury. Attorney's conduct violated the non-solicitation rules because he approached Sam on overhearing of his troubles. Number 2 is conflict. An attorney cannot represent a client in a matter adverse to a former client that relates to the attorney's prior representation. This conflict can be waived by a broker in writing. It's not clear that attorney's representation of Sam is in any way related to the prior representation of broker. This may not be an issue. The attorney would need to determine whether he had received any confidential information in the course of the prior representation that would be relevant to the current representation. If so, there may be a conflict. I think what he did here is something that people very much struggle with on essays. It's something that I am like struggle not to do, right? A little bit of hypotheticals, right? It's not clear. If this, there may be a conflict, right? That allows you to get more points. Again, don't do that at the detriment of addressing the main issues. I tell students this, examinees, this, prioritize. When you issue spot, you should kind of be issue spotting and then real quickly, put a check next to the ones that are really important and write about them first, Don't write about things in order of like how you want your essay to look because the reader's going to know when you're rushing and it's not as good. Write about the things that are priority issues and then you could go back and, piece together your essay. I'm writing a book that I'm releasing on Monday. You all have no idea how I constructed that. I may have written some of it on notes in a hotel room. I may have written some of it on my iPad, and then I might have copied and pasted, like, you know what I mean? But when you read it from head to toe, you're gonna be like, oh, nice. This is a full body. That's the same thing with this. You're allowed to piece things together, but I would focus on addressing the main issues first, and then hopping in with these. If Tommy was an astronaut on the moon, then, whatever. All right, and finally, although an attorney and a client can agree in advance to a fee structure, any fee must be fair and reasonable to the client considering the nature of the work, skill and experience of the attorney, time pressures, and novelty and complexity of the issues. Fees should be disclosed up front, which the attorney probably did. However, because it's a non-refundable flat fee, he should disclose the fee in writing. Because this fee is considered earned on receipt, attorney could deposit into his own account and need not put it in his client trust account because there's a flat fee for the engagement and non-refundable. So they're saying like if it wasn't a flat fee, it would have to go in some sort of escrow account, or we would potentially face issues of commingling. All right, cool. Yeah, so Zach said a nice catch-all that he uses when he's stuck on ethical issues. Florida lawyer professionalism obligations include contributing skill, knowledge, and influence to further the professional's commitment to the service and the public good and enhancing the legal system's representation. too long didn't read, Florida lawyers got to represent the legal industry well, right? Exactly. You are all representatives of the legal industry. I had a tough question for my class, and this is where it kind of actually has inspired me to push people to start writing things down, because I was a little frustrated with the lack of writing. But constitutional officers, who are constitutional officers? Let's say the mayor, let's say the governor, or the sheriff, or the CFO, or the property appraiser, or the tax collector, or the attorney general, or the public defenders. Isn't that pretty interesting? That's a lot of you. You guys are, some of you already are, and some of you are about to be constitutional officers, and you are representing the state of Florida when you for better or for worse, right? The state of Florida. No, it's for whatever. You're representing the state of Florida and the legal profession, and you want to do that to the highest standard. So it's kind of like my tutors, they're representing Ibis Prep. They need to represent to the highest standard. So just real quick, I'm going to fly through this one, see what happened. Can we accept the fee arrangement? I don't know, can we? I'm sure we're gonna have to disclose it to the client and get their consent in writing, and it's gotta be pretty reasonable. But let's see. This is solid, right? This is solid, I think, in terms of length. But again, I'm pushing you all to greatness, right? To first place finishes, not, oh yeah, we made it across the finish line. Like, hopefully I get a participation trophy. Like, I don't know if you guys have realized this by now, but I'm not the guy for participation trophies. I'm the guy to be like, yo, my team, championship, or that's it, right? That's literally it. All right. An attorney must charge a fair fee for his or her services based upon the complexity of the case, the amount of time it will take, what other similar attorneys charge, the attorney's experience, etc. An excessive fee is one that a reasonable attorney would look down upon. I like that. An excessive fee is one that a reasonable attorney would look down upon. Contingency fees are permitted in civil cases except for domestic matters like alimony and child support. What a perfect transition into the second part of class. Contingency fees are not permitted in criminal cases. This is a non-domestic civil case, so Amy and I could agree upon a reasonable contingency fee. Florida sets a sliding scale for 15 to 40%, depending on how far the case gets and the damage from the case. 50% would fall outside the normal range, and as such, I should agree to a lower contingency fee, right? Imagine attorneys saying I should get a lower contingency fee, right? It doesn't seem to happen much in reality, but on the bar exam, yeah, actually, you know what? I'm getting a little bit paid a little bit too much for this, and I think I should get a little bit less, right? That's what you should argue. All contingency fees must be in writing and signed. I would also need to provide Amy with a client bill of rights, disclose any fees and whether they could come out before or after the fee is calculated, and advise her that she can get out of the arrangement 3 days after the signing. Yeah, that's one of the things that if you sign a contingency fee, they do have a few days where they could revoke it. And they do need a calculation of how the contingency is going to be determined, and a calculation when it is determined to show that it was apportioned as planned. So, I think you can all continue to do what I'm doing. And when I started this course, it was a small group course. I used to be like, hey, I don't have you guys for much time. I'm just going to show you study methods, and then I need you to do this on your own time. I came to realize that a lot of people did nothing on their own time or were very ineffective on their own time. So I just kept adding to the time where I could control the study, right? So that's what I did this administration. We started sooner, we ended later, we covered more subjects, we added more questions, added more assignments. We just did more because I just really want to push greatness. I want to thrust greatness upon y'all. So, be confident that you saw all the reviews I showed at the beginning of class. We've been doing this for years with ultimate success rate. And I think that there's no reason that this administration shouldn't be Ibis's best ever until next administration. All right, we're gonna talk about family law. Family law, if you remember, there's a mnemonic that we use. JV pieced with a side of mustard. I didn't come up with this, don't get mad at me. So the J is for jurisdiction. That's gonna be subject matter jurisdiction and personal jurisdiction. Personal jurisdiction is very similar to how you just know about PJ, like consent, domicile, minimum contacts. Subject matter jurisdiction, you're really remembering the 6 month rule, like where the kids live for the past 6 months, or where either parties resided for the past 6 months, or domiciled, something like that. And venue, like where the cause of action accrued or where any of the defendants resided. And that's going to be the first thing that you think about is jurisdiction and venue. Have a little discussion about whether we're in the proper place and whether they have the power to hear the case. And if there's a divorce settlement, the court that issued the settlement will have continuing jurisdiction over any petitions or modifications, anything like that. So we start with the JV, and it's just about jurisdiction and venue. Then the P is for parenting plan. The E is for equitable distribution. The A is for alimony. The C is for child support. The E is for Esquire fees. We're going to cite Rosen v. Rosen. And the D is for divorce or dissolution. And then the M would be for modification. Jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, Esquire fees, divorce, modification. Smooth, right? If everyone could just have that. And again, look, if you see family law, Tommy's married to Johnny, they have a kid, just write that on the side of your paper right away. JVPs, jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, Esquire fees, divorce, modification. Why? Because you want to get your mind churning. Like I notice so often, if I have students in the morning, people are not like me in the morning. I'm up. I'm probably the first one up in this. First one up, last one asleep. I probably am. Maybe not last to sleep, actually, knowing y'all. You guys probably 6 in the morning, whatever. But when I'm up in the morning, I do sessions with students and I see it in them. They get questions wrong. Like first one's wrong. Like, are you sure? Like, I think it's B. And like, oh yeah, like, you know what I mean? I'm like, bro, you have no time for that on test day. You guys got to hit the ground sharp, right? So one way to do that is mind activities. My new favorite thing, I'm gonna start volunteering there on Tuesdays and Thursdays in Coconut Grove. Coconut Grove Elementary School and Ransom Elementary School have a chess club. They play chess. And there's this dude, I watched him do this. I was like, this is what my job should be. Like, this is what I should do for a living. And I'd be so happy. It's like 12 kids at the table. They all have the chessboards. The dude just gets to walk around and play all 12 of them at the same time. And then they're like, all the kids are like thinking about their next move. And then he just goes like, boom, 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 boom. And he beats them all. I'm like, that would be my dream, just beating 12 elementary schoolers at chess at the same time. And they loving me for it. But anyway, I started talking to the dude. I'm like, yo, this program is awesome. You're the man. And he's like, yeah, it's really great. And the first thing he said to me was, it's really great to get the kids' minds working early in the morning. And I'm like, yes, that's what my students need to do. You're not that different from the elementary school chess players. I need you to get your minds working early in the morning. So one way to do that is when you start the test, write down the thing that you're going to use, just try to memorize it. You might be like, wait, what's the P mean? Oh, I can't remember it. It'll come to you, but get your mind working, like don't go into this test ice cold. I can't stress that enough. I'm as you'll see, if any of you come to the corporate run, I'm not just a mental competitor. I played a lot of sports in my life and I know how to compete, and it's not about being cold. It's always about having a sweat and being ready, because people who are your opponents, they can smell that, they can sense that, they can feel that. And this test is going to be the same thing. If you come into it cold, you might have a cold start. So one way to warm your mind up is what I just did. JVPs, jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, Esquire fees, divorce, and modification. Side of mustard, right? You just wrote 9 things that you're going to write on any family law essay and run right through it, right? Yes, Grace, overconfidence is a huge killer. I've passed 4 bar exams. I had to do the math. I've passed 4 bar exams in my life, 4 for 4. I passed the Series 7, Series 66, SIE. I've done it all. Every single time I go into that thing, I pray. I'm humbled. I think, nothing's guaranteed. And every single time my results come out, I pray, I'm humbled. I think nothing's guaranteed. I'm never like, oh yeah, I passed this. You know, people say that like, oh yeah, of course you passed. You're the teacher. And I'm like, I didn't get to study, man. I was teaching the whole time. Like, I don't know if I passed or not. We'll find out, you know, like be humble. Be very, very, very humble. Certainly. I appreciate that, Grace. Overconfidence is a killer. Never too high, never too low. Yesterday's home runs do not win today's ball game, you know? Just because you got certain scores in practice has no bearing on what you're going to get on the question in front of you if you don't take the time to think through it, right? Every question is an island, every essay deserves your attention. Yeah, I like what we got going on. Now let's jump into some family law essays. So please, someone stop me. Actually, I'll stop myself. If we do what's assigned, but I can just figure it out. So what is assigned? Oh, who's that? Man, you guys let me live with that beard? Yikes. Let's see what's assigned. Every year when I do these videos, you see like the progression of ugliness, and then I get the haircut. All right, someone already turned it in. All right, so February 21 and July 2021. That's easy for me. We'll just stay away from 2021. That was like a forgotten year anyway. So any year but 2021 will suffice. I want to do earlier years, right? So anything we see about family law? No. Staying away from 2021. Anything we see about family law? Yeah. We're gonna stay away from 2021. Anything we see about family law?
I think the last exam had a family law question.
Yeah, they just haven't released that one yet.
Oh,
But I appreciate that thought. So you can see family law is not tested super heavily like the other ones, but would it be something that they could do, go back to back and surprise you? Of course. Of course, indeed. Here we go, family law. Now this one has dependency issues, so you know you don't really want to learn too much about that. All right, let's see what's going on with this one. Discuss whether uncle has a legal obligation to report to the Department of Children and Families the behavior of wife, the boyfriend, or both regarding the children. Discuss whether you have a legal obligation to report to the Department of County of, see, this is this dependency. Discuss whether a legal grounds to terminate wife's parental rights. That's better. Assuming wife's parental rights are terminated and she consents, does the law require anyone to consent to uncle's adoption of the children? Ooh, adoption. That was just tested on the last exam. And then discuss the legal rights of any of husband's parents regarding termination of wife's parental rights of the adoption. So real quickly, let's just see if Will, and I called him Will of Attainder. That was his name. I always, you know, we had albums and album covers. He came up with XXX post facto. That was his name. XXX post facto. I came up with Will of Attainder, but I'm not allowed to name people. See, look, what did Will use? MJVP. Can't believe it. Modification. So it doesn't have to be anticipated anymore, right? We got rid of that. A substantial showing of a substantial material change of circumstances. Right? Jurisdiction, right? Parenting plan, best interest of the child, used at least 5 times. I like that. Decision-making authority, sus. That's like the word of the day, right? That's sus. Shared, ultimate, and sole. Shared is what they prefer. Ultimate is, you know, Tommy does math, Sally does football, and then sole is like probably what we're going to see here. One part of danger to the child. They're an abusive drunk. But remember, Florida, you do have a constitutional right to be involved in the upbringing of your children. So they would have a really difficult showing to really take away parenting rights. Equitable distribution, marital property versus non-marital, alimony, they've taken away permanent. We have temporary, pendente, rehabilitative, durational. There's one more, right? Can anyone think of what it's called? Oh, you know what? That's why. I would do it like that. Okay. Child support, everything else. Say Rosen be Rosen. If you do that, you're a legend. And then dissolution, no fault divorce state, irretrievably broken, mental incompetent in 3 years or more. They can order counseling. It's never worked in the history of the universe. I don't know if your parents were on the brink of divorce, if your parents filed for divorce and got ordered counseling and then they got back together and lived a really happy life, I'm sorry for that assumption. I just don't see it happening. It's kind of like the 5K. I mean, someone could beat me on my team. I just don't see it happening. All right, let's see what they're talking about here. So I'll kind of read this over quickly here because we're really focused on the essay, but let's see what's going on. Wife and husband are divorced. 2 children were born during the marriage, daughter and son, since the divorce. Son was only a few months old. Husband has no contact, paid no child support. Deadbeat. Both children have lived full time with wife and her boyfriend. See, savior. Except last year when the child spent several months living with the husband's parents. Okay, so the husband's a deadbeat, but at least the parents are involved, the grandparents. While the children were with the husband's parents, wife entered here we go. Inpatient substance abuse rehab program on her own, but failed to complete it. Oh, you gotta give her an A for effort. Uncle is concerned that wife and her boyfriend are not providing a safe home. Thank God for uncle. Uncle knows that children live with the wife under a court-approved case plan. Uncle has repeatedly observed wife using illegal drugs. Uncle's also seen boyfriend hit son. Oh man, never mind. I said he was a savior, but he's like Eminem's stepdad in 8 Mile. Hit son in front of wife hard enough to leave welts on the son's arm. Uncle is hesitant to report the substance abuse and the hitting because he's afraid that. So this is getting into dependency a little bit. In addition, uncle has recently learned from DNA testing that husband is not the father. Right? Uncle wants to adopt the children. He thinks the wife might consent. Husband would likely object. Well, husband, you're not the father. Uncle emails you a friend from college because he knows you practice family law. There we go. Good for this guy. In the email, uncle recounted the facts and drafted return email to uncle. All right, uncle, this is what we want you to do. So this is about dependency, legal obligation to support child abuse using DCF. You don't have to worry about that. Attorney obligation to report, duty of confidentiality. Okay, so I like what they said here. The duty of confidentiality runs to both actual and prospective clients if the attorney has met with client to establish a permanent representation. The duty is broader than attorney-client privilege, which applies to communications between the attorneys for the purposes of representation litigation. The duty of confidentiality survives the death of the client. However, the rules of professional conduct do allow for an attorney to break the duty in certain situations. It's mandatory in order to prevent a crime. It's permissive when they believe it's necessary to obey the RPC to prevent substantial harm likely to be committed when the attorney is defending himself against charge from a client. Watch this. Needed to be had. Duty of confidentiality. So it's CDC. Whatever, I'll do that on my own time. But I know I said I do it on my own time, but sometimes I don't get to my own time. This commercial is brought to you by Ibis Prep. All right, back to it. So I just wanted to take that moment to learn. I'm a huge proponent of taking moments to learn. Every moment is special, and that was some good pieces we learned right there. All right, let's talk about termination of parenting rights. Termination of parental rights is considered serious action and when presided by a judge and fully adjudicated, even though it's a civil proceeding. The circuit court will have exclusive jurisdiction over such proceedings. Parents facing a termination of parental rights are protected by the Due Process Clause of the United States Constitution and by the Florida Constitution. The U.S. Constitution guarantees parents facing a termination of parental rights the right to counsel. Goes beyond statutory right under Florida. Further, the government must prove its case in a TPR by clear and convincing evidence. There's a higher standard than the preponderance of evidence, blah, blah, blah. So this is, again, mostly getting into dependency. They don't really test on this so much because it's the DCF, but just know the takeaway from here is that you have a constitutional right to the upbringing of your children, and it's very serious action if they are going to strip you of the parenting rights. So if uncle's allegations are true that the mother's still using drugs, then they might be able to pull them away. All right, I don't want to get into that too much because I don't think they tested so much since they removed dependency, but they're definitely not giving us clear and convincing evidence of what's going to be tested. We have to be prepared. All right, here, this one is about adoption. People were shocked that they saw adoption on the last test, but it's been tested before. In Florida, anyone can be adopted, including adults. Adopter can be either married couples, individuals adopting a single parent, a spouse adopting the biological children of a spouse. Consent for an adoption is required by the parents, a child if they're over 12 years of age, and the state or guardian of a child. Parental consent is not required if the parent's rights have been terminated, or alternatively, if that parent never acknowledged paternity and child was born out of wedlock. Abandonment of the children goes towards showing abandonment if parent never stayed in touch with children. Importantly, the Supreme Court of the United States, with Florida following, has held that when a child is born during a marriage, paternity by the husband is presumed, regardless of whether he's actual biological child of the children. As the son, in order to adopt, uncle would need to consent of the husband, the father to complete the adoption. Termination of the mother's rights do not terminate father's rights. For this statement, what I know is that you assume the father if you acknowledge it in writing, or if you are more than 95% determined by a DNA test. I could see this though, if you're born during a marriage, we'll assume there's a presumption that you're the father. But I live in Miami, and some of these women and men and non-binaries cannot be trusted. All right. As to son, in order to adopt, uncle would need the consent of husband, the father to complete the adoption. Termination of the mother's rights do not terminate father's rights. If uncle can locate father, father can voluntarily and knowingly consent to the adoption. If uncle cannot find father, he can seek to initiate a termination or parental rights against him, abandonment of children. Again, I don't want to get so into this because they're using DCF language. I don't love that. And then grandparents' rights. Florida gives protection to grandparents. Grandparents here would have a right to receive notice of the TPR proceedings. They also would have rights to challenge adoption by the uncle. They have preference rights such that they might have a better case for being assigned custody of the children. In Florida, grandparents would also be entitled to visitation rights to the children while the mother's care and if put into custody in anyone else's care. Big takeaways from this essay: constitutional right to the upbringing of your children. They could strip you of that right if you're posing a threat or detriment to your child, and that adoption, anyone could be adopted, and grandparents have rights in Florida, and they have rights to receive notice of termination of parental rights proceedings, and they can challenge adoptions, and they have preference rights, so they might be a better case for being assigned. So if the uncle tries to adopt, the grandparents can jump in and be like, hey, these are the reasons why we think that we should adopt. So
I'm just wondering, what is TPR? In the
termination of parental rights.
okay.
Yeah, it's a proceeding. It's a proceeding that would strip one parent of their rights. Be like, oh, Tommy, like you're a bumbling drunk who beats their kid. Like we're gonna end your parental rights. And what else?
Oh, I was just wondering, like, what date was this essay? Just to take note.
Yeah, it was July 2018. But remember, all that stuff with the DCF dependency, like that essay, the two essays I assigned are good. I mean, I didn't want to go over them because I've assigned them. That essay is not truly indicative, in my opinion, of what a family law essay will look like on the bar exam because of all the dependency pieces. So I don't want to touch on it too much. Let's see.
Yeah, but the grandparents, I think, out of the whole essay, that's important to note because the last time I tried taking the exam, they did mention grandparents in the adoption.
Yep. All right, let's look at this one. This one seems to be more similar. So I think this is the essay we'll go over today and probably call it an afternoon because I want to give you time to do what's most important. Write the two essays assigned for this weekend, which are the two family law essays. That's like, get them knocked out and then spend the rest of your time this weekend diligently studying material, turning weaknesses into strengths, and getting ready for next week. Next week is going to be very, very important week, right? It's the last week of full study, and we have proctored exams on Monday and on Wednesday, and then final review on Saturday. And that's that. The MBE course wraps up tomorrow with our Sunday workshop. I may add in another Sunday review potentially. But let's finish up with this essay and take some time to really absorb it. So Harry and Wendy are both 40. Yikes, I'm almost there. Not really, I'm 34. I got 6 to go. After divorcing after 16 years of marriage. See, that's why I never got married, because I see the end of it too much. Not that I don't ever want to get married. I just thought that maybe I would get rich first. Both parties agree that their marriage is irretrievably broken. Furthermore, it's undisputed that the dissolution action was filed in the proper court. All right, so they're telling you it's the proper court. They're telling you it's irretrievably broken. It's time to hang it up. 16 years, they got married at 24. If any of you are 24 and married, good luck, I think anyone can do it, but may the force be with you. All right, the financial affidavits of the parties reveal the following income: $5,000 a month from Harry's salary as an Air Force officer, $1,000 a month to Wendy from her mother's trust. In addition, the financial affidavits disclose the following assets: $50,000 in Wendy's separate bank account, which came from her mother's trust, and the $400,000 beach house in the Northwest Florida they live in. Harry bought the house 2 months before the wedding for $165,000 with $15,000 down. The 15-year mortgage was paid off using his salary. This is clearly getting at equitable distribution, marital versus non-marital property. Clearly, we definitely want to know that well. Harry has been mostly overseas, but when he took care of the home and the twin boys born 4 years ago. Twins. Henry's parents live nearby and help with the twins. After being stationed near home, Harry filed for dissolution of marriage. He wants equal time sharing and waives child support. Ooh, waiving child support. We'll see if that's going to be allowable. Usually, it's tough to agree to waive child support. You can agree to waive alimony, but waiving child support is not ideal because the child might need support. When overseas in the future, he wants his parents to keep the twins. Henry claims sole ownership, so we got to talk about different types of custody. Now, my instructor Jeremy, former instructor Jeremy, who is a family law attorney. I don't know too much about him actually. I mean, I know that he was passed the background check and was a good tutor, but can't dig into all their lives. But he was he's a competent family law attorney, and he said that they don't use custody, they use time sharing. Now, you'll probably see this model answer using the word custody, but I'm just letting you know what he said. You can kind of go with either word, I guess. So, sole ownership of the house and half of the bank account. He objects to any payment of child support and alimony to Wendy. Yeah, good luck. Wendy's about to get that check. So Wendy is worried that Harry will take the twins overseas. Wendy has never worked before, but she's a job offer in Mobile, Alabama, 100 miles away. She's going to have to petition to the court. You used to have to petition if it was over 50 miles. They've kind of stripped that and said that even a move under 50 miles can still require a petition. She wants to move there with the twins. The job includes housing, but little pay. I mean, these are all considerations. Best interest of the child, best interest of the child, best interest of the child. When he seeks alimony, we want to talk about different types of alimony: child support, half the house, the bank account for Harry to keep her as a life insurance beneficiary. See, that might be a little bit tough, right? That one might be a little bit tough, but we're going to go through this. Messy. Speaking of messy, names rhyme with messy. Jesse. Jesse came in here, the family law attorney. He deals with this stuff all the time. Me, I would rather jump into a pile of nails than have to mediate this type of situation, but different strokes for different folks. So you are the law clerk for the judge who's been assigned the case. I prefer dealing with super anxious law students. That's my cup of tea. You're the law clerk for the judge who has been assigned this case. The judge asks you to prepare a memorandum identifying and analyzing the contesting issues, including the recommended course of action that the judge should take when addressing each issue. This is a great essay for us to read through and absorb. And then if I were y'all, take a lunch break and then write the 2 family law essays. That would be my recommendation. But different strokes for different folks. So let's see what we're gonna have here. 2 from read date. I like that. I always set it up as a memo. I would say this memo would address, because I'm kind of OCD with how I write essays, but you're allowed to do whatever you want. You've seen the model answers. There's no perfect formula. There's just model answers that have received passing scores. So let's check out how this went. And this is not the shortest essay the world's ever seen, so strap on in. All right. Harry and Wendy may properly divorce. The first issue is whether Harry and Wendy may properly divorce. Florida has eliminated fault-based divorce. In Florida, a couple may divorce if the marriage is irretrievably broken down or if one spouse becomes mentally incompetent. For divorce predicated on an irretrievable breakdown, only one spouse need believe that the marriage is irretrievably broken, right? Like Tommy's like, oh, I still love her. She's like, I'm out. Moreover, the court may continue the proceedings for 3 months to allow the couple to reconcile, right? They may, It's not usually the most effective measure. For a court to have subject matter jurisdiction over divorce, only one party need to be a Florida resident. In this case, both parties agree that the marriage is irretrievably broken, thus the divorce has proper basis. Second, the facts state that the dissolution was filed in the proper court, and nothing in the facts indicate that jurisdiction is in dispute. You see, they still got points, just kind of telling the reader, like, you gave me these assumptions, I'm just going to tell you a little bit about them. I really appreciate that. Alimony, huge. The next issue is what, if any, alimony is available and to whom? In Florida, both spouses are responsible to financially support one another. Alimony is determined based on the financial needs of one spouse and the ability of the other spouse to pay. Beautiful statement. Alimony is based on the financial needs of one spouse and the ability of the other spouse to pay. There are several different types of alimony that are currently available in Florida. Temporary alimony. This type of alimony is used for the spouse needing the support while the dissolution proceedings are going on. So similar or identical to pendente lite. I don't fucking know. Temporary alimony. The type of alimony is used for temporary alimony or pendente lite alimony during the pendency of the litigation. I can definitely spell that word. I certainly can't pronounce it. Bridge the gap alimony. The type of alimony is used to bridge the gap from married life to single life, right? Bridging the old gap. Rehabilitative alimony. The type of alimony is provided so that the needing spouse may develop the necessary skill set via education and training so they can find proper employment, right? When me and Sally were married, were engaged and getting married, I was in med school, but then she was like, Andrew, I need you to take care of the kids. So I dropped out of med school and took care of the kids. Well, now baby, I'm going back to med school and you're going to have to pay my way, right? That couldn't be the situation. Durational alimony, this type of alimony is designated for a specific period of time, and permanent alimony has been eliminated in Florida. Now we have short-term marriages are 0 to 10, 10 to 20 is a midterm marriage, and over 20 is a long-term marriage. These are factors that are considered in awarding alimony and how much. There's many factors that are considered in alimony. Some of these factors, and here you just want to give them a list, include age of each spouse, duration of marriage, current income of each spouse, other sources of income for each spouse. In this case, you know, they're going to go through the discussion. They're both 40, they're divorcing after 16, duration is not available because it's not long enough. It's got to be over 20. Wendy has not worked before, so she's going to need some money. She's only 40. Nice. So there's still time. Yes. Hell yeah. With proper education, training for her obtaining gainful employment. Absolutely. Absolutely. That's the best statement we've heard all day. However, at this moment, she requires some financial support, so we're going to need some bread. As such, she's going to be entitled to temporary alimony, bridge the gap, and rehabilitative. Once she's on her feet, she may not be entitled to the alimony. Therefore, this juncture, if the judge awards Wendy, if one or not more, it would be the first three. Child support. The next issue is whether she's entitled to child support. Both spouses have an obligation to support their children. Florida uses an income-based share plan to award child support. The court is entitled to deviate 5% from the guidelines without citing reason. That's a good statement. There's statutory guidelines and they can deviate 5% without citing a reason. That should be a C. How dare they edit this for grammar? That would only take them 7 minutes. Here, Harry earns $5,000 per month, whereas Wendy does not work. Depending on how the parenting plan discussed below comes out, Wendy will likely be entitled to some level of child support. That, of course, may change depending on the parenting plan and whether the twins end up spending more than 40% of the time with Harry. Harry says that he waived child support. Here we go. Child support cannot be waived in any sort of agreement, prenup or postnup. Thus, this waiver would be deemed ineffective. You can waive alimony as long as it's, not unconscionable and there's no duress and all that. But you can't waive child support. Therefore, the court should probably award Wendy some of the child support, depending on the parenting plan. Best interest of the child, best interest of the child, best interest of the child. Let's talk about the parenting plan. The parenting plan includes two portions, time sharing and parental responsibility. There's a presumption that the child spend equal time with each parent. There's a presumption that the child spend equal time with each parent. There's a presumption that the time spent equal time with each parent. However, the superseding factor is always what is in the best interest of the child, the best interest of the child, the best interest of the child. Under a time sharing plan, both parents should have equal time with each parent. However, certain factors may come into play: who raised the children, where they go to school, where they want to stay. The older they are, the more will factor in their opinion. There may be other factors as well. The second prong, responsibility, includes ultimate and parallel. So this is the word I was looking for, ultimate parallel, which we called, let's see what my man Will called this. I knew there was another word for it, parallel. Yeah. Ultimate, soul and shared. Shared / split. Ultimate, actually, I think that the model answer is incorrect. I think ultimate and parallel are the same, but let's see what they say. However, the superseding factor is always the best in your child, blah, blah. Ultimate and parallel. Under ultimate, each spouse is solely responsible for certain responsibilities, schooling or medical. Under parallel, those responsibilities are shared. So that actually makes more sense. So, shared, split, parallel. That makes sense. Ultimate is just ultimate. So all right, anyway, we know there's 3 types. When it's, split, like so that they're kind of doing them parallel amongst each other, where it's ultimate, where it's like kind of compartmentalized or sectioned off, like math versus science, and then there's soul when, the bumbling buffoon. So under parental, these responsibilities parallel, they're shared, and under ultimate, they're solely responsible for certain responsibilities, schooling, medical, football, baseball, whatever. In this case, when he's been here, you're gonna kind of go through this argument. As far as parental responsibility, Wendy would probably be better suited, Harry's often overseas, whatever, best interest of the child. Therefore, the court should recommend that Wendy's entitled to her time with the twins while Harry's overseas. It's also likely that she will bear the greater parental responsibility. This ruling will also affect the amount of child support that should be awarded. The next issue is whether they can relocate. See, it used to be this, that if they intend to move more than 50 miles away, they have to show the burden of proof and petition to the court. Now it's any move. So you could say, well, it used to be 50 miles. Now, if they move at all, they bear the initial burden of proof. They must show that based on numerous factors, such as job opportunities, child's choice, and other factors, if moving, they must provide a new address, how time sharing will continue, and other requirements. It then shifts to the opposing spouse to show why the move would be improper. So it has to be a petition to the court here to move. It's 100 miles away. That seems pretty far. The court should allow them. Finally, distribution of assets. Florida's utilized equitable distribution. Huge. You had to talk about equitable distribution here. Under equitable distribution of assets is not necessarily controlled by title. The assets are first identified, then assessed, and then distributed in an equitable manner. How the assets are distributed is determined by a variety of factors, namely income, need, duration of marriage, among others. Assets that are separate include those that were owned by the respective spouse prior to the marriage, or gifts or devises to one specific spouse before or during the marriage, right? So things you inherited or things you had before the marriage. I always say this. I worked hard, bought my house before I ever got married. So, if you're coming after me, you're not coming after my house, right? That's going to be my own non-marital property. But then once I get married and the money starts coming in, that salary is, that pension or whatever it may be, is part of the marital unit. So assets acquired during the marriage or any appreciation due to some sort of contribution from the other spouse, not just by virtue of the market. To separate assets during the marriage are considered marital assets. There's the marital assets that are then assessed and divided. So you want to split between marital and non-marital. Non-marital is retained. Marital assets will be split equitably. So here they say the bank is a separate account. It's from the mother's trust. So Wendy's keeping it. Here they say the house. This was interesting, right? Because he purchased it for 165, but he only put down 50K. Right? You didn't really purchase it. You actually are having a mortgage, and the mortgage, it wasn't purchased together, but the remaining balance is more complicated. It was paid entirely from his salary, but still the salary is split because she was taking care of the kids while you were working. So it's a factor. She's the homemaker. She caretakes. She's doing a whole lot. There's contribution. Therefore, the value should be considered marital property and equitably divided. The remaining increase in value without any other facts provided, right, would be entitled to that value. So that's like a good piece of it. Like he's saying the increase in it, because it was his decision to buy it, it was his investment that he made beforehand, is his. But the actual principal that they paid off together, or he paid off with his salary, but as a home unit, should be split. Again, complicated. That's what people like Jesse figure out. I'm just like, the answer is C, you know? Everyone's got to pick their path. Therefore, 150K should be divided equally, whereas the remaining should belong to Harry. Whatever, it's just an argument, and then it's complicated. Now, here's the one thing that we definitely want to take away. There's no way Wendy is getting the life insurance policy. And I'm just about to start teaching securities again, financial planning again, and all that. I do teach about life insurance. My partner James is a licensed life insurance agent, so I actually understand life insurance pretty well. And you are the holder of the policy. You could change the beneficiary the day before you die. Like, the beneficiary has no vested right in your policy until you die, you know? Like, my policy, I have a whole life policy, are my brother's. But let's say, you know, my brother pisses me off one day. I'll change it to, you know, my nephew, right? It could be anything. I probably should change to my nephew. I like my nephews. But that's the point, right? You can't get an interest in someone else's life insurance policy as a beneficiary. You could get an interest in like their pension, or, you know, something that you've accumulated with them. But life insurance is totally separate as the beneficiary. There is an argument though, because the premiums were paid, that split, that may be a piece of it, you know, again, that's for Jesse to decide, but I kind of agree with them that, you know, it's by virtue of the divorce, Wendy will by operation of law no longer remain the beneficiary, and they're essentially wills substituted, which terminate by law upon divorce. That's one thing to note too, when we're doing wills and we're doing family law. Divorce, more or less, is like your partner dies. They're totally taken out of your will. You know, it's not like, oh, well, he wanted Tommy to get that. Like, no, she would not want Tommy to get anything. She hates Tommy. She left him and never speaks to him again. Like, we assume that divorces are pretty opposite of amicable, and you're totally removing that person from your inheritance or your estate. But if there's some things that, you know, like alimony or child support, or accounts that they're entitled to distributions from, you know, it does linger. So I think the greatest advice I could give everyone here is get a prenuptial agreement, right? But I think that's just something that people don't really do that much. But let's see. I'm gonna go ahead and stop the recording. There's a few questions I'll answer off camera, but just for the nature of time, thank you all so much. I'm gonna go ahead and stop this recording.